Hello everyone, thank you so much for joining us for this week's featured webinar, Section 17A of the MACC Act 2009, What In-House Counsels Must Know. My name is Raj and I'll be the moderator for this session. I just wanted to, before I go into introducing the speakers, I just wanted to talk to you about the topic for today. Prosecution for corruption offences under the MACC Act 2009 has traditionally been initiated against individuals. However, this is set to change with the game-changer new Section 17A. Come 1st June 2020, commercial organizations, board members, and management will also be exposed to liability, where a person associated with that commercial organization corruptly gives gratification. I'll keep it at that because our two superstar speakers will be talking to you about these issues and deep diving into the practical tips to comply. I will now go ahead to introduce the speakers. I'll start with Sarita, ladies first. I know my manners. Ms. Sarita Devi is a partner on litigation practice group. She does litigation part-time, but she's a full-time expert on anti-corruption matters. Sarita, do you want to say hi?
Hi, good morning everyone, and thank you for dialing in for today's session, or what will for a while now be known as the new norm for conferences. So Raj has already been very kind in introducing me. So yeah, I'll defer to Ang.
Next, we have Ang. There's Ang Siak King from our Penang office. He's a Stylo Milo guy and everybody in Penang knows him. Ang, hello.
Hi, hello everybody. Thank you for dialing in. My name is Ang Siak King. I'm the head of the corporate commercial practice at Zaid Ibrahim and Co. Penang. Thank you.
Okay, so in terms of the flow of the webinar this morning, we have some technical issues in terms of the Q&A. So there won't be a Q&A function. But what you can do is actually to email us your questions, and we'll take those questions and respond to you after the webinar. Okay. So, but in the course of this webinar, I'm going to throw some very difficult questions and put our speakers into the spot and try to roughen them up a bit to give you some tips on compliance with the upcoming Section 17A of the MACC Act. Okay, let me get straight into it. Ang, I'll throw you the first question.
Okay.
Okay, so, Section 17A imposes liability on commercial organizations. Now, my question to you is this. What must in-house counsels be concerned with the new Section 17A? What type of liability are we looking at?
Okay, thank you, Raj. Good question. Okay, now, having known the background of Section 17A, I think we should be very worried. Because why? Because the scope of responsibility and the penalties are severe. The new section makes commercial organization, be it a company or partnership incorporated in Malaysia or carrying on business in Malaysia, responsible for corruption offences committed by person associated with it. This includes your managers, your employees, agents, and also potentially service providers in its customer or supply chain. Liability is imposed if the organization obtains or retains business as a result or otherwise receive some form of business advantage. The commercial organization has a defense only if it can show that it has enacted adequate procedures to prevent bribery. The penalty upon conviction is severe, which is 10 times the bribe, or ringgit 1 million, whichever is higher, and it could couple with imprisonment of up to 20 years. That's why we got to be very careful and take note of these new penalties, new provisions. Back to you, Raj.
Okay, but Sarita, that's okay, right? Because, well, if the company is held liable, surely a company can't go to jail. So why must in-house counsels be worried?
Thank you, Raj. Well, that's a big misconception. So if I can straight go to slide number 20, the answer is actually within 17A itself. You have to look at 17A sub 6, which sets out who are associated persons. So if a company is found, or a commercial organization is found liable, be it an investigation stage or if they are charged for corruption, The actual people that, if you're talking about an imprisonment term, the actual people that will face those imprisonment terms are those set out under Section 17(6), your directors, partners, employees, or generally senior management and above. So to say that it's only the company's liable, so if it's a fine, the company will pay for it, that's a huge misconception, because senior management, board members, chair people, you could all be potentially looking or facing fines as well as a jail term.
Okay. I mean, traditionally, companies have always taken out directors and officers insurance for their directors and also certain senior management, right? Now, would a D&O insurance cover work for Section 17A liability?
Okay, thanks, Raj. Maybe I can now get some help to refer our audience to slide number 5. Okay, all right, let me start. In most cases, commercial organization may take up D&O insurance only in respect of defense and settlement costs, and only where the director or manager is acquitted or the proceedings are discontinued. This is because Section 289, subsection 5 of the Companies Act 2016 prohibits company from effecting insurance against director liability to pay criminal and regulatory fine. There is no equivalent restriction for partnerships and limited liability partnership. Additionally, if authorities are aggressive, they may seek a conviction under a director's separate duty to exercise reasonable care, skill, and diligence. This duty is provided for under Section 213 of our Companies Act, and arguably, it is an additional responsibility on directors to ensure that adequate procedures are put into place so that the company is not liable under Section 17A. So, if prosecution is sought under this section, i.e. Section 213, on the duty to exercise care and diligence, there's no opportunity for a company to obtain D&O insurance, even for defense costs. So this emphasized again, how we started our webinar today, the management must pay extreme care to Section 17A. Back to you, Raj.
Okay, for the audience, you've seen our speakers have been referring to a deck. What we'll do after the webinar is to actually email this deck to you, and you can refer to it later. Okay, so I'm going to now move on to the villain in this whole Section 17A, the associated person, right? This is the person that's causing all sorts of problems for organizations, and this is the whole problem that Section 17A tries to cover. I'm going to go back to you. Now, so every in-house counsel, every company now is looking to design their compliance program. And any compliance program should, I think, start with identifying who are a company's or a commercial organization's associated persons. Would you just let us know who would come under this definition of an associated person under Section 17?
Okay, yes, Raj. Can we go to the next slide, please? Yes, slide number 6. As you can see from the slides, these are the outline of the associated person. Under Section 17A, associated person is defined to include director, partner, employee of the commercial organization. These 3 categories of people are quite easy to discern and identify. Yeah? Let me repeat: director, partner, employee of the commercial organization. Plus one more category of people, which is a person who performs services for and on behalf of the commercial organization. And this category of people is further elaborated to mean that it has to be determined by reference to all relevant circumstances and not merely by reference to the nature of the relationship between him and the commercial organization. This category of people is the one that makes things a bit difficult to determine who they could be. All right. So I determine by reference to all relevant circumstances and not merely by reference to the nature of relationship. In our view, I think the following could be person deemed or as the person who performs services for and on behalf of the commercial organization. Your agents, your collaborators, your joint venture partners, and potentially your independent contractors along your supply chain. This could all be considered as a person who performs services for and on behalf of their commercial organization. Thanks, Raj.
Well, so whether or not you have a contractual arrangement in place with these people, could it be like an informal arrangement?
Yes, yep. So long as even without reduced in writing, but you ask the particular person to do something for you, that person will be deemed as a person associated with you.
Okay. Okay, Ang, since you're on a roll, I'm going to keep this with you. Sarita, don't be offended. Yeah, let me just one more question to Ang, and I'll go back to you. Okay, now I had this question from a client before this webinar, and I thought this is a very interesting question. So now, just follow me on this question, yeah? Okay, so when an employee of a wholly owned subsidiary bribes someone for a project, okay, that subsidiary will be liable under Section 17A. That's clear, we know that, right? Because that employee is an associated person of that wholly owned subsidiary, so that subsidiary will be liable. Now my question is this: would that parent company of that subsidiary also be held liable under Section 17A? Because can the prosecution look into whether that wholly owned subsidiary is a person who performs services for and on behalf of the parent?
Okay, very good question, Raj. It's a very challenging question. And I think in view that this Section 17A is very new and there's no court cases been deliberated on this section, we'll answer this based on our understanding of where this act came from. Actually, the Section 17A actually principally based on the UK Anti-Bribery Act. I'll answer that in that context as well. Okay, to start with, there is no specific guidance in Malaysia at this point, but we could take some pointers from what I say UK Anti-Bribery Act. Now, Section 8 of the UK Bribery Act actually provide examples of people, associated person. And if you remember, I'll just touch about associate person includes person who performs services on your behalf. And the UK actually says that subsidiary could be an associated person of a holding company. But then, in our view, liability to the parent does not accrue simply on the basis of corporate ownership or payment of dividend, subsidiary and holding relationship. In the UK, authorities must show that the bribe by the employees was with intent to obtain or retain business or to gain a business advantage directly for the parent or for the group as a whole. This is so even if the parent company indirectly benefits from the bribe as a result of its corporate ownership or through the payment of dividends from the subsidiary to the parent. Now, to discover whether the employee intended to obtain benefit for the parent, in my view, the level of control which the parent exercises over the subsidiary is an important contributing factor. In the situation where a subsidiary does not have substantive independent operation, the parent is likely to be liable. Where a subsidiary operates independently, there is a possibility or good reason or argument to establish that the intent to obtain a business benefit was directly for the subsidiary rather than for the parent. The consolidation of profits on the group level does not itself make a parent liable. Yep, this is my view on to your questions.
Okay, so I mean, this is off the cuff. In the sense that wholly owned subsidiaries on one side, you have to definitely take into account whether these pose a liability to you. And when we go into M&A, structuring joint venture deals and all, this is also something that we have to look into now, right? With this new Section 17A on due diligence and how extensive do we need to carry out due diligence on say, a joint venture entity, joint control with another third party, right?
Exactly. That also brings to the question that when we craft our shareholders agreement, our joint venture agreement, be it incorporated or unincorporated, we do have to bear in mind the ability or the exposure of your counterparty exposing you and make you liable.
Okay, now I'm going to go to our Sarita before she shouts at me for not asking her a question. Okay, Sarita, now we know the Section 17A has got extraterritorial application. and it would apply to a foreign entity carrying on business in Malaysia. What does carrying on business in Malaysia mean? We cover a situation where the foreign entity has sales agents in Malaysia carrying out sales on his behalf.
Okay, thank you, Raj. That's a good question. So if we can just move back to slide 20, just for ease of reference, I'll take you directly to subsection 8B. This is the section that gives 17A extraterritorial jurisdiction in Malaysia. So what it means is that you could have a company incorporated in BVI, the US, the UK, it doesn't matter, but they can be liable under 17A so long as they are carrying out business in Malaysia. Now, the term carrying on business in Malaysia is very wide, and it does not mean that you need to have a subsidiary company established in Malaysia, or a branch office, or a foreign office, or even some sort of a joint venture setup. The example you gave, Raj, of a sales agent, that would also amount to carrying on business in Malaysia. It could even be a distributorship agreement. So long as you're carrying on business in Malaysia, and if your sales agent or if your distributor were to give bribes in order to obtain or retain a business advantage, then that can expose that foreign entity to liability under Section 17A in Malaysia. Thank you.
Okay, now, Sarita, just going on this extraterritorial application. So yes, foreign companies having operations in Malaysia, having representatives in Malaysia are exposed. Now flip it the other way. Now, if I was a Malaysian I was in-house counsel for a Malaysian company, but I have operations outside of Malaysia, say in countries where there is no corporate liability provision for corruption offences. But one of my, agents in that foreign country commits corruption, right? Can I be charged in Malaysia under the MACC Act?
Yes, you can. Because if you were to look beyond Section 17A, and if you were to look at the MACC Act, the MACC officers have powers to trace and investigate assets or incidents of corruption that even takes place outside of Malaysia, so long as it involves a Malaysian company. So it is very wide-reaching, and it has extraterritorial powers both within the context of 17A and the wider context of the Corruption Act itself in Malaysia.
Okay, wonderful. We are good in terms of timing, and we've covered up who are associated persons that poses liability to a commercial organization. I want to move to the next topic which we have in mind, which really is the most important one that every company wants to know. What do we need to do to satisfy the defense of adequate procedures? Sarita, I'll go to you first. Now, we know that a company must implement adequate procedures. And we also know that the defense of adequate procedures is a risk-based assessment, correct? Now, in your experience, what must in-house counsels look out for in the company to identify high-risk businesses or operations? I mean, we can't be looking at every business stream in the company, right? So how do we prioritize business streams, operations, where we do implement this adequate procedures defense program?
Thank you, Raj. If we could have slide number 11. This is a very subjective question, and unfortunately there is no one-size-fits-all sort of answer, as it really depends on the type of business or industry that the commercial organization is involved in. For example, if we were to just take the oil and gas industry, from my experience, a division or a department that would be most susceptible to corruption charges would be procurement. So for a GE within the oil and gas industry, you should pay more attention to your procurement division to ensure that you have enough safeguards in place and to also ensure that there is compliance. And for another department that would also be important to look at, and this regardless of the type of industry you're in, would be finance. Because when it comes to gratification or bribery, most often than not, it involves monies going out, monies coming in, and would most often than not involve some kind of a check or invoice being approved by the finance department. So if you have enough safeguards in place, at the top of my head, it would be things like having 2 level of approvals as opposed to just 1, would definitely help to combat or minimize corruption.
So in your view, in your experience, procurement, high risk, right?
Yes. Finance
would be high risk.
You'd also look for any department that deals with all your third-party contractors, agents, distributors, contractors, or even departments that look into renewal of contracts. You know, it can be something as simple as a renewal of a canteen mess. There could also be corruption there, and there could be pockets being lined or kickbacks being given in order to retain the particular contract. So it really depends on what drives or what moves the industry that the commercial organization is in.
Ang, can I ask you, I mean, what do you think? In your experience, how would you prioritize in terms of the risk exposure the businesses or the operations of the company have?
Okay, thanks, Raj. Now, I would like to share with the audience on the projects that I'm currently working on that gives some insights of what we have found, because we have been engaged by a few clients to draw up the adequate procedures things. And those clients that I'm working on, I will consider in a high-risk industries. So that gives you a bit of real-life examples of the things that we look on. So based on those, I'm currently doing 2. Based on our experience of these 2 cases, I agree with Sarita. I think the business procurement, i.e. the sales, always come as number 1, top, yeah? And also the next thing that we discover is actually liaison officers, yeah? People who liaise with authorities, with governments for approval and licenses, that either for new license or something that require renewals, are also in the high-risk areas. So let me elaborate a bit. For sales procurement, from those cases that we have looked into and did our due diligence, kickbacks can be demanded by procurement officers or potential customers that do not have anti-bribery measures in place. And the complexity and structure of the business procurement models to us determines the risk of bribery. A long or a longer supply chain with many intermediaries, for example, you have many agents, distributors, or business partners, in between naturally increases the risk of bribery. Commission-based remuneration models also increase bribery risk, especially when transaction value or project margins are high. Yeah. So for the procurement bit, these 2 factors are important. The structure of your supply chain and also your remuneration model. These 2 will tend to give rise to higher risk if a longer supply chain or the remuneration package is very much dependent on commission on success basis. Okay, as I say, again, I may refer you to what in front of your screen, which talks about the adequate procedures under the guidelines from the Prime Minister Department. Yeah. So if you look at that, you will see that the law and the PM Department's guideline demands that much more stringent measures are put in place where business procurement models are structured with a higher risk profile. Second, commercial organizations are forced to consider whether their high-risk models are even necessary. Are a complex series of distributors, agent, business partner necessary to do business? These are the questions that we have to ask ourselves. Is a business procurement better move in-house? Yeah, instead of engaging external party to do it, could it be done in-house? Are commission-based reward models necessary? Should the organization consider hybrid model with more fixed payment to reduce risk? These are the questions that we ask our client when we undertake a risk assessment exercise on this aspect of the business. Okay, next, I did talk about there are 2 main areas. Number 1, from our experience, is actually the procurement. The second one is the liaison bit, especially liaising with to get license, to renew approvals and things like that. This is another potential high risk area. Sometimes we need to pay some facilitation payment, to get things done. So this team that liaise with the relevant party are also in the high risk areas, and these are the area where we will say that you need stringent compliance measure such as financial controls, review invoices to ensure that the service fees are not inflated to include facilitation payment by employees or any third-party service provider. Let me repeat again. Third-party service providers are potentially person associated with you. Yeah, this is always the category of people that you do not have direct control as opposed to directors or your employees.
Okay,
yep, Raj.
Sorry.
Okay.
Thanks. Okay, Sarita, I just wanted to ask you this. Now, I mean, having a compliance program, getting consultants in, expensive lawyers like you, it involves some amount of cost. And at these challenging times, companies are trying to be prudent with spending. So now, with that in mind, how would you advise your clients to come up with a cost-effective compliance program? Now, can I ask you this? Can we just have, say, one anti-corruption policy in place, carry out one training session, and then we'd be done with it?
Thank you, Raj. A very relevant question, especially in today's climate. So in today's economic climate, cost is most definitely a concern for businesses. And at the top of my head, an efficient cost-cutting measure, but still to ensure that the organization is protected in terms of liability from Section 17A would be to focus more on the defense of adequate procedures as opposed to the statutory defense of due diligence, which is available to the individual members of senior management. Because if you were to look at Section 17A, it actually consists of two tiers of defenses. So the second tier, which is the defense of due diligence, which is applicable to individual members of the organization, will only be effected if the company itself is either investigated or charged under Section 17A. So if the company can fully avail itself of the defense of adequate procedures, then there is no need for the second tier defense to even kick in. So I would say that businesses can invest more on ensuring that they have sufficient adequate procedures in place so that in the event of an investigation or charge, they would be able to avail themselves of that defense. And another measure that I can think of would also be to pick a division within your organization for training. This is where you can get your external consultants or external lawyers to train, and in turn, that small team can then train your whole organization. Because organizations differ from size. You have them as small as 10, you have them as large as 5,000 employees. Now, say we take a larger organization that has 5,000 employees. If you want to do training for all 5,000, it is definitely going to be time consuming and very, very expensive. Because for training to be effective, it cannot take place on a large scale. You can't have or cram even 1,000 people into a room and expect it to be an effective training. So you could, pick perhaps your legal team or your compliance team or even your HR team, and you train them. You train them well, you spend that cost, and in return, that team will then become trainers for the rest of the organization. So this is what we call changing your employees to become trainers. So that's also a cost-cutting measure. And you could also look to focus on high-risk areas that we had discussed earlier. Depending on the type of industry or business that you're in, it could be procurement, as Ang mentioned, the liaison department, or finance, so because within an organization, you may have many different divisions. So you may not be able to invest all your time or cost in ensuring that every division has got sufficient measures and it's also being complied with, I mean, that would be an ideal situation. But if we can't achieve that, then the best bet would be to just start or choose your high-risk areas first. So I think everyone agrees that procurement is most probably the highest risk in any organization should you have, because it's unlikely that any organization does not have a procurement department. You know, procurement can even be as, it can start as small as just hiring of your employees or hiring of staff, and it can go as large as your supply chain and million-dollar, billion-dollar contracts. So these are just some of the cost-cutting measures at the top of my head and from my experience as well. Thank you.
What do you think, Ang? How do we, you know, like in-house counsels want to make sure that it's cost effective? I mean, can we just have very limited, just to show, you know, just to show the investigators when they come in to say, hey, look, I've got this policy, I've done 2 or 3 trainings this year, I've got adequate procedures in place. Do you agree with that approach?
Okay, Raj. Before I answer that, I think let's re-look at certain important principles behind it. I think, again, I would like to invite the audience to look at the slide in front of you, which talks about what constitute adequate procedures based on the guidelines from the Prime Minister Department. So, or what we call the trust guideline. Yeah? Number 1, it must involve top-level commitment. Number 2, you must have a risk assessment being taken up. The details are on the slide in front of you. And then you got to undertake control measures as systematic review, monitoring and enforcement, and T, training and communication. So the guideline, which is issued pursuant to Section 17A, did put down what needs to be done to set you a very good guidance of what adequate procedure is. And at the same time, I would like also to share with you a decision in the UK actually the name of the case is Skansen, Skansen. Sarita will probably may share with you more later. Which basically says that in that case, the jury actually returned a verdict of guilty of corruption, because basically it says that in that case, simply having a non-specific policy and normal accounting controls without incurring some cost and management time or introducing some bureaucracy into the day-to-day operation will be insufficient to afford the adequate procedure defense. So with these two in mind, I would say that the shortcut of drafting a policy and providing training will not be sufficient to build an adequate defense. However, of course, we are also very mindful of the situation now. Preserving cash management is in place in everywhere. So it's bearing that in mind, that how do we go about doing it? I echo what Sarita has said. Are you going to concentrate on the high-risk areas? Because adequate procedures is still a risk-based approach, which acknowledges the different procedures will be appropriate depending on the size of your organization, the sector you are in, the jurisdiction in which you do business, nature of your business partner and transaction. So the procedures must be proportionate to the risk faced by the organization. So therefore, first, you can consider which are the highest risk area in your organization. Involve your top management in this process. Anyways, legal requirement. Often, marketing, procurement, regulatory liaison are the highest risk group. I'll just share that. We may focus our effort to design a system to prevent risk in this group first. Yeah, procedure for the larger organization as a whole may be built over the time. For procurement, you may mean restructuring your customer onboarding process, doing due diligence on the personnel and invoice involved in the business relationship. Basically, you build on what you have. You do not need to reinvent the wheel all entirely, but you can build on what you have. That is a way to save your costs. And also the system must have implementation data, i.e. records of our bribery prevention procedures are being implemented So it is important to keep good record. As I say, you can build on it, you enhance it by having a good record system. And this is very important because a lack of record is effectively a lack of adequate procedures, and the defense may fall apart. So what is the example of a good record? The obvious ones are attendance to training and written copies of policies. For high-risk areas, authorities will expect to see record of how the company has adjusted its business processes to prevent bribery. For example, implementation of non-financial control, such as rotation or relationship manager, restructuring commission-based bonuses, or a completed due diligence checklist or invoices in the transaction that have more than a low risk of bribery. Yeah, so these are examples that some experience that we can share, and that you're able to still build adequate procedures without causing a big hole in the company's pocket. Yeah, Raj.
Thank you, Ang. Okay, Sarita, Ang just showed off with his knowledge on UK cases. I mean, can you give us some examples of reported cases in the UK, just to provide some context into how do we implement adequate procedures?
Yes, we have a couple of cases that I've highlighted as well in our deck. So perhaps if we could go to slides 8 and 9. So I'll just quickly touch on two, well, these are, I think, two of the biggest cases in the UK, if not the world. It involves Rolls-Royce and Airbus. So these are instances whereby, well, Rolls-Royce in particular, they were involved in a systematic payoff scheme spanning over 24 years and spanning across different jurisdictions. And how they got caught is it was via a whistleblower through one of their former directors, I believe. And in Airbus, it's also the same situation of the special fraud officers in the UK found that there was also a methodology of systematic payouts or kickbacks in order to, one, secure contracts or to retain a business advantage that they already have. And in both these cases, an important point that I would like to highlight is you are talking about the enforcers or the senior management itself, the people who should have been ensuring compliance with all your anti-bribery policies and all your safeguards, but they were the ones indulging in such practices. So when you have such a situation, then all the adequate procedures that you have in place, the safeguards, the compliance, the policies may very well just be rendered redundant. So one way around such instances is if Rolls-Royce or Airbus had like an audit committee. So that's one way. And the audit committee should not be made up of just your chair people, your board members. There should be a mixture of everybody from different business units within the organization. So this is also to ensure that if there was a payment made or if there was a payment that was not due. For instance, I was involved in a particular investigation where a contract had not even been signed. It was awarded to a party, but it had not even been signed, but there was already a payment being made. So that's a little bit peculiar, because when you've not even signed on the dotted line, there should not be any payments being made. But this payment was to line pockets of certain entities or individuals to obtain that particular contract. And it was brought to the board's attention through an audit committee investigation. So it's just one example of how an audit committee can be very useful in instances such as Rolls-Royce and Airbus. And another policy that commercial organizations can think of investing in order to avoid instances like Rolls-Royce and Airbus. I mean, if you are a GE in an organization as big as these, would be to also enhance your whistleblowing protection, because they should be, your policy should actually encourage whistleblowing. they should be rewarded and they should not face any repercussions from reporting on a colleague or reporting on a supervisor or even reporting on a director. So if you have strong whistleblowing measures in place, then there's also a chance that such instances as corruption at the top level is bound to come out a lot earlier, and the organization can get ahead of it. So if I can also just touch on the Skansen case, which Ang has already touched on. This is a good case because both the cases that I just mentioned, Rolls-Royce and Airbus, these are cases that has not yet been litigated in court, because what they've done is they've entered into a deferred prosecution agreement with the UK government. But Skansen is a case that has gone on to court. And in Skansen, it involves a local British company that had given a bribe to secure a local construction contract worth about £6 million, I believe. And why the court held that they could not avail themselves of the adequate procedure defenses was because some of their defenses were things like, oh, the contract already had a clause prohibiting corruption, so that is sufficient. That's not. Having a contract saying that bribery is not allowed or corruption is not allowed does not equate to having adequate procedures. Same thing with an anti-corruption policy. So if you have an anti-corruption policy in place that merely states, do not give bribes, do not take bribes. I mean, that's pure common sense. That would also not avail you of the adequate procedure defenses. And in Skansen's case, that was the kind of policies that they had, bare minimum. It did not really go on to explain how or the measures that the company is undertaking in order to avoid corruption. So, you'd be talking about your authority, limiting limits of authority, or having multi-tier approvals. These are the type of procedures or policies that the government, or in our case, your MACC officers, would be wanting to see in order for the commercial organization to be able to avail themselves of the adequate procedure defenses. And in Skansen's case, which I think Ang had also touched on, he had a lot of policies but no training. So now you also see a lot of cases whereby companies have your HR policy on a web portal. So when a new employee comes in and you sign the forms and they're told, okay, go and read the policy on the web portal. Definitely something like that is insufficient for the commercial organization to be able to avail themselves of the adequate procedure defense. Or even a printout is not sufficient. You need to have trainings, and you need to also ensure that there is compliance with those policies. That's very important. There must be a correlation between the actual policy and the compliance with the policy.
Okay, Sarita, thank you. Thanks, Sarita. Now I want to move to the next bucket, which I think is very important, and companies must take this into account. Now, any compliance program is foolproof, and an investigation can be triggered by anonymous tip-off, a whistleblower, or even from a competitor complaint. Now, how do in-house counsels and how does a company be prepared for potential investigations or raids by the regulator?
Thank you, Raj. This is a very practical question, so I would answer it in two ways. One, the commercial organization should have a dawn rate policy, and two, they should also have taken steps to ensure that their dawn rate policy works. Now, what is a dawn rate policy? A dawn rate policy is simply a set of rules or guidelines that tells the employees what to do and what not to do in the event of an unannounced raid. I'll limit this to unannounced raids because with an announced raid, it's a little bit more it's easier because you know when they're coming, you know exactly what they're asking for. So your regulatory authorities in Malaysia, they have two ways. Some, they write you letters, they tell you this is exactly what I want, this is exactly who I want to see. Or some, they come in guns blazing, 10 officers, they are at your door and I want everything. I want to take your servers and I want to see all these people. So in my experience, so I deal a lot with unannounced raids, especially by MACC officers. And from my experience, I see that the commercial organization exposes itself to liability when the raid is not carried out properly. So you have a set of do's and don'ts. So when the don'ts are triggered, that is when you're gonna, liability is bound to arise as well. So a simple example would be you have a receptionist, you have 10 officers coming in. If you have a policy in place and if your receptionist has been properly trained, then they would know that the first thing to do would be to get the credentials of the officers, sit the officers in a secluded area, something like a meeting room, because you don't want a situation of the officers freely wandering around your office and to be able to speak to any staff, and to also ensure that the correct person is brought to the scene ASAP. This can be your GC, head of legal, compliance, or even HR for that matter. It's up to any organization to decide who they want to be their raid response team. It can even be external counsels. But that's fluid and can be played around. So that's just an example. Another point I'd like to touch on is with having a policy like the anti-corruption policy, you must ensure it works, because different industries may require different type of dawn raid policies. For instance, a standard set of do's and don'ts may not work with regards to a bank, because with banks, you've got your FSA and they've got their disclosure policies. So you also ought to, and how you test actually your dawn raid policies is by doing your mock raids. And we've done many mock raids and I find it extremely relevant and useful, because you then know whether, from a mock raid, you will know which department within your organization is weak, who is not complying, who has no idea that there's even a dawn raid policy, or what to do, what not to do, what works, what doesn't work. So these are just some of the examples and the best ways to ensure you come out with your head held high in the event of an unannounced raid.
Okay, thank you, Sarita, for that. We have actually gone, we've done with the key topics, and what I'm going to go into next is actually, we've got some questions from the audience, actually some very tough questions, which I think will pose a challenge to the speakers. I'm going to take out a few questions because I'm also conscious of time. For those questions that I don't read out, don't worry, we will email the response to you, or maybe, we can contact us, we can discuss this further. This is a nice question from one of the members of the audience. I'm going to ask you first, and then Sarita, I'm going to ask you the same question as well. All right, now with Section 17A, with Hari Raya coming up, Deepavali is next, and it's common practice to send gifts, host dinners and stuff like that, right? Now, with Section 17A, should I stop all these things now?
Oh, good question, Raj, Okay, I think my answer to this is that the context in which the gift, the dinners are thrown is very important, And we live in Malaysia, we are very hospitable people. My view is that I think the question is, if, for example, giving of hampers, are the hampers part of our cultural norm that does not communicate any intent to obtain business? Probably yes. I think a lot of time we give all this is appreciation for the friendship, for support, good working relationship, So therefore, I think it's the context in which it's given. If the value of the gift is excessive, for example, for you give somebody a hampers that have something worth 100,000 ringgit, for example, then it is not likely to fall within the norms of ordinary business, friendship, or etiquette, But if it's, let's say, for example, a 200 ringgit, a Hari Raya hampers to the CEO of a company who can can more than afford it, I think the answer is that should be fine, you know. A buka puasa dinner at a local hotel seems ordinary in our culture. However, if you purposely arrange for somebody to go to Hong Kong to eat at a Michelin star restaurant as a, you know, a Raya buka puasa, then I'll probably say that is not in the norm and very likely to be construed as a bribe. So I think it depends on the context of what happened and what gift you give. Raj?
Okay, thanks. Sarita, I wanted to ask you the same question, but there's another question that came in which I thought was really interesting, and I'm going to ask you this. Okay, now if my company becomes aware that a counterparty paid someone in my company for a contract, right? So it was procured with bribes. Can I then terminate the contract with that counterparty? Is it legally unlawful termination, or how can you justify the termination?
Okay, thank you, Raj. So this is where you have to understand the distinction between a contract to commit fraud or bribery and a contract which is procured by bribery. So in the former, if you have a contract to commit a fraud or bribery, that's definitely illegal and it will not be upheld by the Malaysian courts. But if a contract is procured by bribery, then it becomes a voidable contract. And what that means is that the innocent party can choose whether or not to continue with the contract. So for instance, say you have organization A who gives a bribe to someone within organization B. So organization A here is the giver and the innocent party would be organization B, because it was not the entire company that was bribed, but it was an individual in the company that was bribed. So when the bribery comes to the attention of organization B, they can decide whether or not to continue with the contract or to terminate the contract, because they may have concerns whether A can actually carry out the contract. You know, is it the most competitive price? Do they actually have the expertise, the experience? Because once there was a bribery, everything comes into question. A could have very well been the most suited or the best suited person to carry out the contract, but the power still lies in the hands of the innocent party. So it's up to B to decide. So to say that a contract which was procured by bribery cannot be upheld is wrong. It ultimately depends to whether the innocent party in that situation wants to continue with the contract.
Okay, thank you, Sarita. Thank you, Sarita.
Thank you, Raj.
Quick question, we're conscious of time as well. So if you can take maybe just like 30 seconds or so to answer this question, okay, I'll be grateful. Because you mentioned earlier that we're looking at the trust principle, right? And the trust principle says you must train your employees and also. This question just came in from one of the audience. Apart from my employees, do I also have to train all my vendors, consultants, my customers? Do I have to go to that extent?
Okay, thank you, Raj. I think this has to be looked at by, and if, for example, you will build these adequate procedures to prevent briberies, how different is it from the practice that you are currently undertaking? It involves a very detailed and very elaborate ways of preventing this from happening. Then the next question that you have to ask is whether a communication itself is sufficient or not, you know? Most than not, a lot of time when we have an effective communication with the vendors, with the customer consultant, that this is our policy, you shouldn't do this, you shouldn't do that, you're allowed to do this or allowed to do that. If that is enough and you have effectively communicated with your vendors and customer, I think that's sufficient. However, if it involves something more elaborate, which is something that you probably believe that without some form of training, it will not be effective, or can it get it across effectively to your vendor and customers, then I would say that some form of training will be necessary on top of that communication.
Yeah, I mean, I think some of one or two of my clients have also implemented systems where, you know, they have to go through training before they are actually onboarded as a panel vendor or consultant of the company. So it becomes mandatory.
Yep.
Okay, with that, I have to seal off the questions because we are at 11:55. We're very good on time. It brings us to the end of this webinar. Thank you so much for joining us. And Sarita and Ang, thank you so much. I enjoyed the session. I hope the audience did too. So for the audience, the presentation slides and recording of this webinar will be sent to you via email, and it's also be made available on our website. Next Wednesday, please join us for our next Wednesday's webinar, which yours truly will also be moderating. We will be talking about post-COVID-19 pivot to digital adoption. What are the trending legal considerations in terms of digitalization? I will be moderating a panel of speakers. We'll be discussing key issues including personal data protection, e-contracts and also e-signatures, the trend with cashless payment solutions, and also how do we do virtual AGMs, EGMs, and also board meetings. So please join us for that. The invitations will be sent out to you soon for those who have subscribed to our mailing list. So please keep an eye out for that. Alternatively, please visit our events page at zico.group. Once again, thank you so much for joining us. I hope to see you next week. For my Muslim friends, Selamat Berpuasa. Thank you, everybody. Stay safe.